The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation building series, The Law and You. This is program number 926, coming to you on Monday the 11th of February 2019. On this program, I will speak to you on the topic, the election petitions. But before getting into the topic, one very short preliminary, namely, expressions of condolences go out from me to all families which have suffered recent bereavements. Now for the topic for the evening, the election petitions. History was made this morning when, for the first time, certainly as far as my knowledge and recollection goes, the High Court sat in the NIS building. That has been brought about by the circumstance that the election petitions were accorded priority. As we know by now, the High Court sits at the old courthouse downstairs, that is the criminal assizes, and over in the Correz building we have the two female judges sitting over in the Correz building in their courts, Justice Henry and Justice Bayer. The master sits also in the old courthouse building. It was felt inexpedient to have the election petitions heard in any of the available spaces. Normally, the High Court would sit upstairs, the courthouse, which is the formal premises of the House of Assembly. But it was considered better to have a temporary court in the NIS building in the conference room to hear the election petitions, so that even though there might be adjournments, you wouldn't have the case where you want to adjourn the court, but there is no place for that adjourned sitting to be held. So they started sitting in the NIS building tomorrow. And the law allows the authorities to declare any public place a temporary courthouse, whether for the High Court or the Magistrates' Court or indeed the Family Court. That declaration was duly done. As we all should know by now, a fresh judge was appointed to hear the election petitions. Coincidentally, his name is Justice Stanley John, the same name as Stanley John QC, lead counsel for the petitioners. Can't recall having met Justice John, but my information is that they started the sitting this morning. On this program, I would like to give you an idea as to the sorts of decisions which Justice John will be required to make. The public has lamented the fact that these petitions have taken so long and are still going through the legal process. The elections were held since December of 2016. Petitions were filed soon after that. But because of some procedural hearings and appeals, the petitions have become dragged on. The process has been dragged on. One side blames the other side blames their opponents. As far as I could tell, both sides are to take a lot of the blame for the fact that these cases are still going on. But there it is. The cases have reached the stage where evidence is now being taken into the allegations made by the two petitioners. And just to recap, the petitioners were the losing candidate for the NDP in Central Leeward and the losing candidate for the NDP in North Windward. Both gentlemen filed petitions alleging that they were disadvantaged, that the law was broken, that many things went wrong during the election processes, and they are alleging that, look, they didn't deserve to lose, and they want the court to do something about it, in a nutshell. Therefore, the court must now inquire into the allegations made by the petitioners and the responses of the various government officials against whom those allegations were made. One of the unusual facts of this case, or these cases I should say, is that I have seen what has purported to be a lot of the evidence of alleged wrongdoing in newspaper articles. I've heard things on the radio. I've seen things on the television. So in a sense, there has been pre-trial matters aired in public. I hasten to say that these matters have no effect on the judge who was hearing the petitions, Justice John. No effect at all. Even if Justice John had been stationed in St. Vincent and the Grenadines, which he isn't, but even if he had been stationed here and had been, let us say, forced to listen to a lot of things, when a judge comes to try a case, the judge puts out of his or her mind everything that he or she has read in the paper, seen on television, or heard. Judges are not easily influenced by that sort of thing. So that the nation of St. Vincent and the Grenadines can expect a clear, uncontaminated judicial approach from His Lordship, and the nation can expect a judgment reflecting the findings of His Lordship on the contentious issues of facts and his conclusions on the issues of law, which will be canvassed before him by both sets of lawyers. So that's the first thing I want you to understand. Whatever decision this judge makes would be uninfluenced by anything other than purely legal considerations. Now, the same can be said of all cases heard in the High Court. But I emphasize the point in relation to these election petitions because some people seem to have a view that you can influence a judge extraneously. That is, you can influence a judge by things taking place outside the courthouse. No. No, no, no. The streams of justice run pure in this country. I can attest to that. Now, don't expect an early resolution of these matters. These are complex cases. From what I have seen, a lot of witnesses have to be examined and cross-examined and re-examined. A lot of exhibits have to be gone through, guided by previous decisions made by previous judges on procedural matters. But above all, whenever Justice John makes his decision, either side would be free to file an appeal against that decision. So we are looking at months down the road, not a matter of a couple of weeks, before we get a final decision. And let me say, for the sake of completeness, that whenever the Court of Appeal makes a ruling on election petitions, there could be no further appeal to the Privy Council from that ruling of the Court of Appeal. Our Constitution says that in matters of contested elections, the buck stops at our Court of Appeal. And therefore, whatever decision Justice John makes and whatever the Court of Appeal rules on that decision when it is challenged, and believe you me, these are not cases where the losing side is going to simply close its books and throw in the towel. I am predicting that whoever loses at this hearing before Justice John will file an appeal. And therefore, we're looking at months before the validity of the elections can be set aside, can be settled. Excuse me. Among the things which the judge will be considering when he hears the evidence would be the issue as to the extent to which things were done wrongly by election officials. And the judge would look into the nature of any alleged wrongdoing to determine whether what went wrong, if anything went wrong, was willful and deliberate or purely accidental. Because courts don't deal in perfection, particularly when it comes to the actions of officials. The court would listen to an allegation that so-and-so official did something wrong, which they should not have done according to the election rules. But the court would also go on to consider the circumstances in which that matter or those matters were done wrong, as to whether there was willful disregard of the obligations of election officials, or whether there was purely accidental omissions, purely inadvertence. So the fact that an official is found to have used a wrong procedure doesn't necessarily mean that the judge will say, okay, you used the wrong procedure and we are disallowing that procedure and that is the end of the case. No. The judge has to weigh and balance human error, human frailties, as against gross incompetence, to see what really, if anything, went wrong in the conduct of the elections. And as I understand the petitions, complaints have been made not only about what took place during the voting, but what took place even before the voting, because I understand complaints have been made about the design of the ballot papers. And of course, ballot papers have to be designed long before voting takes place. So there are complaints against the design of the ballot papers, complaints against procedures during the polling, during the voting, and complaints have been made about what happened after the voting. In other words, with the counting of the ballot and the securing of the ballot boxes. Those are things which, according to the information publicly available, the petitioners will be complaining about. Ultimately, the judge would have to decide A, if the complaints are well-founded, B, the reason or reasons for the actions which gave rise to the complaints. But one of the factors the judge will have to consider in coming to a decision is this: the extent to which the victorious candidates had been involved in the things which are alleged to have given rise to wrongdoing and bad procedures. Because there's one branch of election law which says that you cannot punish a candidate for the mistakes of officials unless you can show that those mistakes resulted in the candidate winning, and without those mistakes the candidate would not have won. And that is in accordance with common sense. If I'm a candidate in elections, I canvass, I bring my people to the polling station on election day and do all the things which I believe would assist me in winning. And through no fault of my own, in fact, without my knowledge, things went wrong in the polling station. It'd be hard on me to tell me that I've lost my seat because some official or officials fouled up and did the wrong things. I would say, well, that has nothing to do with me. Why should I lose my seat because X and Y didn't do their job? The judge will have to consider the extent to which, in a sense, the winning candidates can be made to be penalized for errors done, errors committed, mistakes made by election officials. As I said, if the judge comes to the conclusion that it is those mistakes that caused me to win, then the judge will have no hesitation at the end of the day in declaring my election null and void, because the judge will say, look, those mistakes were made in your favor. If they were not made, you would not have won. So I can be aggrieved if a ruling goes against me. Notwithstanding, I had nothing to do with what went on in the polling station, during the poll, before the poll, in fact, or even before the actual voting. So if allegations are made that things went wrong before the voting and during the counting, it all depends on the extent to which those things that were found to have gone wrong, if they were found to have gone wrong, would have affected the result of the poll. Ultimately, the judge has to answer the question: were those elections fair? Were the results fair? Or were the results so tainted with mistakes that the elections can't stand? Now, let me make one point. People have been saying that, well, the government didn't win those two seats fairly, and therefore the government is not legitimate. Well, that is not in accordance with our laws. Our laws are that once His Excellency the Governor General certifies the election results on the advice of the Electoral Commission, the Supervisor of Elections, and so on, once those results are certified and the government is sworn in, the government is presumed to be a legitimate government until the contrary is established in a court of law. So that even if at the end of the day the court rules that the election petitions succeed, or one of them succeeds, you can't look back and say, oh, that proves that all along the government was not a legitimate government. It was legitimate up to the time when the court pronounces something differently. In these election petitions, you will not find many people who are neutral. The supporters of one party would believe in the righteousness of their cause. The supporters of the other party would believe the same in the righteousness of their party's cause. Not many people really sit down to be dispassionate and say, well, look, let us be fair. What is going on here? But persons like myself have to keep a balanced approach. We have to read whatever decisions are made and accept the decisions of the courts, whether we agree with those decisions or not, whether we like them or not, and move on. That is our function. When I say our function, lawyers mainly, as neutral commentators, at least those lawyers who are neutral. Of course, some lawyers are allied to one side or the other. And therefore, at the end of the hearing, when the judge delivers a decision, hopefully, I will come back before you and give you the gist of the decision. Of course, you would have known all about the decision from the news media, but I will hopefully quote passages from the judge's decision to show you his reasoning and why he decided the case one way or the other. And then we will await the inevitable appeal, and hopefully at the end of that process, I will come back divvy and tell you what the Court of Appeal has said. But we still have a distance to go yet before we know for sure what the courts will rule on these election petitions. Fascinating stuff. I have not attended any of the hearings except the very first one, when I held the papers for Mr. Astafan, who couldn't come to St. Vincent, and simply went and told the judge he couldn't be in St. Vincent. That was from the time the petitions were filed. Since then, I have made it my business not to attend any of the hearings. I wait until the hearing is finished. I wait until I've received the judgment, and I read and study the judgment. So you wouldn't see me anywhere near the NIS building for the hearing of these matters. I will be content to be patient and wait. But of course, all sorts of things are being said, wild statements are being made by those who don't know better, or some who know better but who want to confuse the public. I would only urge the public to rest its confidence in the integrity of the judiciary. Let the judge do his work. Let the Court of Appeal do their work when the matter goes before them on appeal. And we have to abide with the outcome whether we like it or not. All right? All right, well, that is all from this edition of the Law and You program number 926. I look forward to be of further service to you next week, Monday, Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.